All right, welcome to Module 6. Our subject is civil rights, which can be viewed as recognition that in the past Americans have not always accepted the ideal of political equality or not always lived up to that ideal. In the past, largely male office holders held beliefs regarding women and minorities that were openly discriminatory, and that led to calls to right those previous wrongs, even as many Americans continue to argue that discrimination is a thing of the past. So what do we mean by political equality? In the assigned reading, it identifies three specific dimensions of equality, and two of which are really central to Americans' political views of equality. The first dimension is the idea of equality in voting, which reflects a generalized belief that each person's vote ought to count roughly equal in whatever state that they happen to live. The Supreme Court's decision in Baker versus Carr in 1962 ruled that federal redistricting first was justiciable, meaning that it's something that the courts could resolve. Previously, a lot of redistricting claims were basically said, those are political questions, we can't discuss them. But they were justiciable under the 14th Amendment's Equal Protection Clause, and that federal districts must be drawn to respect the principle of one person, one vote. In other words, each federal district must contain roughly the same number of voters as every other district in states. Another dimension that Americans tend to find compelling is the idea of equality of opportunity, which holds that everyone is entitled to meaningful opportunities to succeed in society. Now, what does equality of opportunity mean? There's wide disagreement between liberals and conservatives over how to achieve equality of opportunity, with liberals arguing for aggressive programs to provide resources for low-income Americans, and conservatives arguing that government has really little to no role in playing in ensuring equality of opportunity. These things ought to happen more organically. Most liberals view education as a game changer in terms of providing low-income Americans with opportunities to improve their fortunes. They also tend to think that access to adequate health care is an essential kind of game changer in terms of expanding opportunities. A third dimension is the idea of equality of outcomes, which is a more theoretical argument contending that government should play a much more aggressive and significant role in distributing goods, and that goods and services should be distributed in such a way that everyone is roughly equal in terms of access to income, healthcare, education, etc. The most popular kind of example of an equality of outcomes view is socialism, which is based on the view that capitalism is innately exploitative, and that eventually the working people will rise up and seize the government and ensure a more equitable distribution of wealth. Marxism is a variant of socialism. Americans generally reject socialism, and so there's very little support for equality of outcomes, even among liberals. As I mentioned in my previous presentation on federalism, inequality at the time of ratification of the U.S. Constitution was an acknowledged feature of American society and contributed to the outbreak of the American Civil War. Whether you believe that the Civil War was waged over slavery or states' rights, the reality is that deeply embedded in the ideology of states' rights was white supremacy, the view articulated in Chief Justice Roger Taney's majority opinion in Dred Scott v. Sanford, which held that blacks were never meant to be included as citizens under the Constitution, and consequently had no rights that a white man need respect. The victory of the Union over the Confederacy led to fundamental revisions of the Constitution, including ratification of the 14th Amendment in 1868, which includes the famous provision forbidding any state from making or enforcing any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive persons of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection under the law. And equal protection is sort of the real gravamen of most civil rights cases. Equally important in all three of the Civil War amendments are clauses at the end which read, Congress shall have power to enforce this article by appropriate legislation. That effectively means that the Congress has the power to enforce forbidding slavery, ensuring that blacks are treated as citizens, and giving to black men the right to vote. As noted in the Module 5 presentation on civil liberties, the constitutional changes took time for the judiciary to interpret, in my view, correctly. In my sense, it took them a while to get the right meaning of it. And meanwhile, in states of the former Confederacy, white political elites quickly regained power by a variety of means, both electoral and extra, political, i.e. violence. Following the end of Reconstruction, they launched a series of actions designed to subordinate their black populations. For a variety of reasons, neither Congress nor the federal courts intervened for much of the remainder of the 19th century and into the 20th century. The Supreme Court began issuing broader rulings that cited the Equal Protection Clause really in the early years of the Great Depression and really are in the early years of the 20th century and into the Great Depression. The assigned reading notes the significance of a footnote in the majority opinion of United States versus Caroline Products Company, which was a 1938 case dealing with the federal government's prohibition on the sale of filled milk, which was skimmed milk that had other kinds of ingredients added in to make it look like milk. It was called the most famous footnote in Supreme Court history, and basically held that any state regulations that discriminated based on race or ethnic origins must clear a heightened or strict scrutiny standard to be held constitutional. The paradox of American culture is that even as strong majorities of Americans express support for equality, large numbers of Americans continue to hold discriminatory attitudes towards women, blacks, Hispanics, and members of the LGBTQ community. The assigned reading also notes the challenge of segregation, which refers to the deliberate separation of communities based on color or ethnicity. And there are really two kinds of segregation. De jure segregation means segregation in law, and examples include bans on interracial marriage, bans on blacks voting through the use of poll taxes, literacy tests, and grandfather clauses, the latter of which basically meant, if your grandfather couldn't vote, then you couldn't vote. In many states, blacks went to different schools. They were placed in separate, there were separate bathrooms made available, and they were even, there were even segregated water fountains. The rationale for justifying de jure discrimination was the Supreme Court's decision in Plessy versus Ferguson, which established this notion of separate but equal as a standard, basically saying that states could use their police power to keep the races separated so long as the facilities were separate but equal. Of course, the reality was they never were equal, and more importantly, the mere act of separating facilities imposed a stigma on those facilities dubbed to be black. The other kind of segregation is de facto discrimination. That means segregation in fact, and refers to social customs that result in racial segregation in the absence of legal discriminatory mandates. Examples of de facto segregation include segregated neighborhoods, which were often enforced within the real estate community in the form of redlining, which I'll talk about more in a little while. Likewise, shunting blacks and other minorities into impoverished neighborhoods meant that children of blacks and other minorities went to inferior schools, had little access to health care, and often lived in food deserts with little access to grocery stores selling fresh produce. The key to ending segregation lay in yanking out the legal underpinnings that made it possible. The leadership of Lyndon Johnson, combined with Democrats' huge congressional victories in the 1964 elections, contributed to passage of the Civil Rights Act of 1964 and the Voting Rights Act of 1965, which combined to, largely ban de jure discrimination. And I'll talk more about that in a minute. Many racist communities resisted those actions, and in fact, a lot of the hostility towards the federal government today can be traced directly to the racial animus that people felt during that period. De facto discrimination has been much more difficult to eradicate. Discrimination is not always unconstitutional. The federal courts have identified instances where unequal treatment is legally permissible. An example of constitutional discrimination is the Supreme Court's decision in 2016 that the University of Texas's admissions policies created a preference for historically underrepresented groups that was nevertheless ruled constitutional to achieve a compelling interest, which was maintaining a diverse student body. You don't want your flagship university in Texas to be 95% white, given the rising diversity of Texas. You would want to be bringing more Hispanics and blacks and other people, other groups, Asian Americans, Native Americans, onto the university, because you want your students to be exposed to diversity. You want them to see how other people are different and why differences should be tolerated. The assigned reading also notes that the courts have established a variety of tests for determining whether a state or federal policy is constitutional or unconstitutional, and they established what are known as protected classes that generally have the following features: inherent or readily visible traits, i.e. dark skin or an epicanthic fold in the eyes for Asian Americans, historic experience of prejudice or hostility related to those shared traits, limited capacity to protect their interests through the political process, and the meaningful ability to contribute to society. So the last one is basically saying if we eliminate these first three, discriminated against people will be able to do a lot more and make valuable contributions. There are many different dimensions of equality addressed in the assigned reading, including racial, gender, and sexual equality, among others. I think this portion of the reading is important, but it's also self-explanatory. So I want to skip ahead a little bit and discuss the history of the various movements for equality that took place in the latter half of the 20th century, focusing on the African American civil rights movement. The civil rights movement began in the early 20th century and was dedicated to eliminating discrimination in the United States. The oldest of the civil rights organizations was the National Association for the Advancement of Colored People, the NAACP, which was formed in 1909, resulting from race riots. And a lot of times when you hear race riots, you think that it's blacks acting up. More often than not, it's whites attacking blacks, if you look at the history of it. It was primarily northern-based. Educated, northern-oriented blacks living in states in the Northeast. It was focused primarily on using litigation to eliminate de jure discrimination against blacks. But the NAACP also fought a more than century-long battle to pass federal legislation banning lynching. The Equal Justice Initiative reported that nearly 6,500 blacks were lynched in the United States between 1865 and 1950. The Emmett Till Anti-Lynching Act was just recently signed into law by Joe Biden on March 29, 2022. Another important civil rights organization was the Southern Christian Leadership Conference, the SCLC, which was primarily based in the South, and its leadership was primarily comprised of black Southern ministers. The most prominent of which was Martin Luther King. He was influenced by the Indian independence movement leader Mohandas K. Gandhi, who developed peaceful, nonviolent protest tactics to successfully expel the British from India a generation prior to the civil rights movement. King successfully led the Montgomery bus boycott, which desegregated public transportation in the city of Montgomery, Alabama in the early 1950s. Another important civil rights organization was the Student Nonviolent Coordinating Committee, SNCC, the SNCC, which was primarily Southern-based but largely comprised of younger blacks. They were kind of loosely aligned with the Southern Christian Leadership Conference, but they were far more confrontational in their use of nonviolent tactics, much more willing to put themselves at risk in certain ways, employing sit-ins at local diners to force owners to serve blacks. These actions, secured meaningful reforms that significantly reduced overt racial discrimination in the United States over the course of the 20th century. And a number of other things happened too. In 1915, there was a ruling in Gunn and Beale versus United States, where the Supreme Court unanimously ruled that an Oklahoma law using a combination of literacy tests and a grandfather clause that was unconstitutional as a violation of the 15th Amendment. Just prior to U.S. entrance into World War II, Franklin Delano Roosevelt signed Executive Order 8802, which prohibited discrimination in any industry involved in the nation's defense, and established the Fair Employment Practice Commission to adjudicate claims of discrimination, and effectively scourged most discrimination in federal employment out of the national government. One of the more significant civil rights measures occurred in 1948, when Harry Truman issued Executive Order 9981, which effectively integrated the military services and again created a committee to examine all military rules and regulations and recommend changes to ensure durable desegregation of the military. This was another thing that infuriated Southern white political leaders because there were military installations throughout the Southeast that were now suddenly desegregated. And that was disruptive for Southerners and contributed again to a lot of anti-federal animus. Perhaps the most well-known civil rights accomplishment was the civil rights handing down of its decision in Brown versus Board of Education in 1954, which was actually several cases cobbled together where people found black people tried to send their child to a public school. In one case in Topeka, Kansas, the guy was a railroad engineer. He was informed that blacks were not allowed. And remember, this is Kansas. This is not Georgia or Alabama. He got a lawyer and said, well, I'm going to challenge this because I don't think segregation is acceptable. And the Supreme Court agreed, basically finding that in the field of public education, separate but equal has no place. Subsequent decisions further reflected the court's view that public education must be desegregated with all deliberate speed. Again, as I mentioned earlier, huge Democratic victories in the early 1960s paved the way to significant legislation on civil rights in the mid-1960s. The Civil Rights Act of 1964 banned discrimination of all private businesses engaged in interstate commerce and created the Equal Employment Opportunity Commission, which is basically a bunch of lawyers, for the government that are waiting around to sue businesses who are guilty of discriminating against people on the basis of race, creed, or gender, or sexual orientation. The Voting Rights Act of 1965 banned the use of literacy tests and poll taxes for determining voter eligibility. And the Civil Rights Act of 1968 banned discrimination in housing. Now, especially that latter act, the Civil Rights Act of 1968, demonstrated a long-held belief that you can't legislate morality. In many parts of the U.S., real estate agencies engaged in what was known as redlining, as I mentioned above, which basically barred agents from selling homes in white neighborhoods to buyers of color. Attempts to end discrimination in housing also precipitated what is known as white flight, as millions of Americans abandoned neighborhoods in urban areas for suburbs when blacks and other minority groups moved in. Now, There's a lot more to this, to this assigned reading. I hope there's nothing in it that you have trouble with. As always, if there's anything in my presentation or the assigned reading that you're struggling to understand, please bring those struggles into the week 3 discussion. So let's have a great week.